Welcome back to Law and Crime, everybody. Aaron Keller here, along with Law and Crime trial analyst Julie Rendelman, as we continue to listen into the Newman Raja Stand Your Ground hearing in Florida. The defendant is facing a number of charges related to the death of a motorist who was broken down on the side of the road. Newman Raja, the defendant, was a police officer, but he was in plain clothes in an unmarked vehicle, and he pulled up behind that person who was broken down. There's a lot of discrepancy as to what happened there. Julie, stand your ground. A hearing, this is to ultimately determine whether Newman Raja, the police officer, will be able to present this theory in a subsequent trial, correct?
Correct. And yes. And so it seems like there's a lot of evidence that is not very helpful to the defendant in this case. I mean, you know, you have to accept the understanding that, oh, God, I think
we can go back to court. It looks like the witness is ready to testify again. A 10-minute break in the Newman Raja Stand Your Ground hearing, which you've been watching and listening to from Florida. I'm here with Law and Crime trial analyst Julie Rendelman. Julie, we saw a pretty good cross-examination of that defense expert.
Yes.
They're really getting into the weeds on this, how far apart people were standing, where weapons were placed, where everybody was, trajectories, reconstruction of the scene and everything. And ultimately, this is all to try to prove or give the judge some sense of whether or not Stand Your Ground fits in this situation.
Right.
The factual scenario here doesn't look good for the defendant, Newman Raja. He's accused of a number of crimes. It's not a top murder case, but he's basically accused of shooting and killing this motorist who had broken down by the side of the road. He pulls up behind the motorist in an unmarked vehicle, plain clothes, with his own personal gun. They have this discussion, and then shots are fired, and the motorist winds up dead. At no point in it does Newman Raja indicate he's a police officer, even though he claimed later that he said he was.
Right, but there's a tape that disproves that.
Whoopsie for him. It turned out that the victim was on the phone with, you know, like a motorist assist organization. Then he's got a credibility problem. So how do we believe him when he says that this victim, whom you're looking at right now, he was a musician? Why do we believe Newman Raja when he says the musician had pulled out a gun and was at risk of shooting him?
Well, I'm not sure what the specific evidence is in this case in regards to whether or not eventually the victim in this case did pull out. He did have a permit. The family has said that he had pulled out the gun because he believed he was being robbed. Quite frankly, anybody who would be alone on the street with a car that broke down, if an individual approached them, gun drawn, no uniform, not in a police cruiser, and approaches them, doesn't announce who they are, I'm going to think that they're robbing me or they're doing something that's going to potentially hurt or kill me. So if he has a weapon and the purpose of having a permit is to protect yourself, then potentially he's going to pull out that gun and get himself killed. I mean, the reconstruction expert that we have on the stand seems to be having a lot of trouble. It seems to me that what the prosecution is showing is that the money he's paying to be a defense expert may be influencing the way he's testifying.
Well, look, when have we seen an expert that gets up there? They all know they're going to get the question how much they're getting paid. This guy just doesn't even know.
It boggles my mind. It's first of all, you're in a court of law, so we're all, and he's testified so many times. We talked about the fact that he testified at Tex MacGyver. This is a guy who's aware of not only how much he charges per hour, but at least some estimate of how many hours he's worked. For the life of me, why would he allow his credibility to be questioned on something so ridiculous? Just answer the question, even if it's an approximation. I mean, we're both sitting here going, just give me an idea of how many hours you worked.
Whenever the prosecutor's got to go into this, well, is it more than this or less than this? You know, is it 10 hours? Is it 50 hours? Is it 100 hours?
And it's so innocuous, and all it does is make the judge, the jury, in certain circumstances, question his credibility about everything. And so if I'm the defense, I'm like, what on earth is he thinking not answering that question?
Yeah, if he just gives a straight up answer, I worked, I put 100 hours into this case, I deserve to earn a fee, here's my fee, it's the market rate, end of story.
And I will say he took no notes, which I find mind-boggling as well. This is a guy who said he's put in over 30 hours. He testified to this. How has he not taken a single stitch of notes in this case?
Is he trying to do it to prevent the other side from getting a tangible document in discovery? But if that's the case,
I find that problematic and troubling. And so, you know, that to me, you know, your obligation as an expert is to know what the heck you're talking about. And if you're going in here, you know, testifying on something of this importance, how you don't have a single note, whether or not it has to be turned over or not is irrelevant. You must be taking notes so that you can have some recollection of what you're testifying to. How many times has he testified before in other cases?
Yeah, look, I mean, ultimately, they've got to boil this down. You know, in order to get stand your ground, you have to prove in Florida that you're in, you know, an area where you have a legal, you know, right to be, and that someone else has placed you in, or someone you're defending, in imminent danger of serious bodily injury or death.
Right.
So here, in theory, Newman Raja could fall under the protection of the defense if he can basically convince everybody that the victim was aiming a gun at him and that he feared he would be shot and that he was in a place where he had a right to be. So a lot of moving parts here.
Sounds to me that the victim in this case is the one entitled to the stand your ground, not the defendant.
Yeah, and I would agree. I'm still waiting to see how many facts come out in this thing, but that's ultimately the stage that we're at with this. So we've got a couple of other cases that we're following here at Law and Crime. Want to talk about a couple of them. The Jeffrey Willis case in Michigan is going to resume yet again for a second trial. You probably remember this guy. He was convicted in the murder of a mother named Rebecca Bletch, who, by all accounts, and the jury agreed, was jogging down the side of the road when she was attacked and killed. That trial resulted in a conviction. You might remember the defendant because the judge didn't even make him sit in the courtroom while relatives of the victim were giving victim impact statements. He said he couldn't take it and he was allowed to leave. Well, this defendant is accused in another murder, and that case is about to start up any minute. To get some more details on it, let's listen to this.
Trial of convicted serial killer Jeffrey Willis is scheduled to begin this week. Willis, who was convicted in late 2017 for the 2014 murder of Rebecca Bletch, is accused of the kidnapping and murder of Jessica Haringa. Willis was arrested in connection with the Bletch and Haringa murders after a teenage girl who escaped her abductor identified Willis as her captor. Police later searched his home and van and charged him with the unsolved murders. Prosecutors contend Willis schemed to abduct women so he could rape, torture, and murder them. Willis is currently serving a life sentence for the Bletch murder and is awaiting trial for the abduction of a teenage girl. For Law and Crime, I'm Rachel Stockman.
That case is expected to start up any moment. Jury selection has been dragging on a little bit longer than we thought, but we are hoping to have opening statements in the Jessica Haringa case against Jeffrey Willis very, very soon. We also are monitoring the situation in the Gaul case in Tennessee. You've got to remember Riley Gaul there, the teenager accused of killing his cheerleader girlfriend. He was 18, she was 16. A couple of different theories as to that case. The prosecution rested its case a little while ago, and just moments ago, the defense rested its case without calling any witnesses, as I understand it. So we're waiting for things to pick up in that courtroom. I think we might be getting some discussion out of the judge right now. So let's listen to what's going on in there. Certainly an interesting move. And sure enough, court just went into a recess in the Riley Gaul case out of Tennessee. Again, that case involving a teenager who had gone off to play college football at an area college, accused of shooting and killing his high school ex-girlfriend who was a cheerleader. A couple of different murder theories in this case. One is that it was premeditated, that he wanted her dead. Another theory that he basically committed the statutory definition of child abuse, which resulted in the victim's death, which in turn elevates, because she died, that charge into a felony murder charge. There's the victim, a cheerleader, a lot of support for her in her community, especially on social media. Julie Rendelman, really interesting move here, because we've got two different theories of the case. We've got the state's case saying, look, this is at a minimum premeditated, at a minimum it's reckless, okay, which the defense agreed with. The defense turned around and said, okay, we'll plead to that charge, but this is not murder. The defense is trying to say that these two had taken their relationship to the physical level, and then she started to pull away from him, and he wanted more, so he started concocting this kidnapping scenario, dressing up as a dangerous so-called man in black, going around her neighborhood, scaring her. hoping that her fear would drive her back into his arms, either because she was scared, looking for comfort, or because he apparently thought in some sick, twisted way that this would result in, her
back together.
Yeah, but coming back together, that he could ride in as a knight in shining armor or something like that. So they're saying, okay, look, firing a gun into an occupied house, minimum recklessness. We'll agree to that. The defense pleaded to that. But is that theory going to hold water up against the state's theory that this was something drastically more sinister?
I mean, we spoke about this the other day because we talked about the fact that the bullet went through the house and entered into her bedroom. So it wasn't
right where she was
right
sleeping.
Where she was sleeping
Overnight.
Exactly. And so we talked about what the defense's theory would be, is that there's recklessness because it was shot through the actual house. It wasn't shot directly at her, and so how would he arguably know exactly where she was? And that was kind of the premise of the whole reckless aspect. I have to say that over the weekend I actually was looking at the diagrams and the pictures of the house, and they actually show, if you recall, like almost a rectangle that shows exactly where she would have been sleeping and shows where he would have fired the weapon. And anyone who knew the victim, which he did, anyone knew where the victim slept, which he did, would know that at 3 in the morning, which I think is when this took place, there's no question that he knew that when he was firing that shot, he was firing into the area where her head was. So I as much as I tried to be open-minded, I think that the defense has a lot of trouble of disproving, and not that they have to, but a lot of trouble of kind of showing in any way, shape, or form that this wasn't an intentional murder when he fired directly into the area where he believed she was sleeping.
Yeah, look, I mean, for a minute, I was willing to listen to this defense theory.
Me too.
And we're looking at some of the pictures of where the bullet hole went into the window. I mean, that's not a wide area of the wall. That's pretty narrow. I mean, you can picture a bed being in that area where you see the laser pointer hitting. So look, I was open to this because I'm like, okay, maybe the guy's, hormonally driven, having these issues. Look, I mean, it's sad. We learned from some of the friends at college that he was suicidal, that he was checked into for some mental health treatment. But look, the trajectory here, I agree with you. Let it be known, Julie Rendelman and I agreed about something for one of the
I feel like
first
you almost
times
have
ever.
to on this. But look, he could have.
I almost have to.
Well, in a sense, we talk about when we try to prove intent when someone gets shot. When they get shot in the arm or the leg, we have a little trouble proving intent. When someone gets shot directly in the heart or the head, you start to say, well, when someone gets shot in the heart or the head, the intent of the person is to kill them. Well, he could have shot anywhere into that house. He could have shot up in the air to make the noise to have scared her. He didn't do that. He made a decision to shoot in the very area where he knew her room to be. And he shot in the middle of the night knowing that she was sleeping there, because where else would she be? Exactly.
Yeah, and it's like he probably knew what side of the bed the pillow was on.
What is a reasonable explanation as to why he would shoot into the room at that exact location other than he's intending to kill her?
Yes, I agree. I mean, so I'm thinking if I were to predict, it's more likely than not that we're going to wind up with a guilty verdict, or that legally it certainly makes logical sense.
Right.
Okay. I would have believed the defense theory had the bullet been fired somewhere else, for instance, up into the ceiling.
Absolutely.
Or said, oh, he's trying to scare her again. Look, and this time he broke the law. It's criminal.
Absolutely.
It's reckless. Lock him up for a while. Do something.
But I think that's what damns him, and that's what we talk about. We talk about the statements he made to his friends. Well, obviously, the statements he made to his friends were inconsistent with, the truth. We know that now. But I had said to you before, without that, you still had enough evidence once they recovered the gun and knew that the gun that was used was the gun that was used to kill her. That bullet hole, to me, is what sinks him.
I agree. So, look, we're talking about the Riley Gaul case out of Tennessee. I agree with that analysis. Here's what's gone on in that courtroom in the last few minutes. We've got the prosecution resting its case. We saw the standard motions to dismiss. The defense also rested its case. No witnesses, no nothing. Interesting move. The defense is going to rely fully on an argument that the state just didn't prove its case beyond a reasonable doubt. That's how it's going to go. Closing arguments tomorrow at 9 a.m. Eastern in the Riley Gaul case. As Julie and I were just discussing, some of the key pieces of evidence in this case were recordings of the defendant himself made by his friends in college after the victim was shot and killed. The friends started to figure out what was going on when the defendant was asking for their help in getting rid of the weapon. The friends went to police. Police gave the friends a key fob with a hidden camera, and they started to record the defendant. Here is some of those secret recordings of the defendant himself. Welcome back, everybody. Some words from the defendant himself in the Riley Gaul case out of Tennessee. The defendant facing murder, felony murder, and a number of other charges related to the death of his 16-year-old cheerleader ex-girlfriend, who prosecutors say was shot right through the head. The bullet came from outside of a home, went through the wall, and struck the victim right where prosecutors say the defendant, Riley Gaul, intended for the bullet to strike. Now, Julie, we know the defense version of this is that the defendant wanted to try to get back together with this woman, and he was coming up with all these bizarre ways of trying to rope her back into a relationship. He's going through the neighborhood wearing scary black clothing. He's staging his own kidnapping, trying to sort of create this air of danger that he could swoop in and somehow comfort her or rescue her or something like that. The defense would like people to believe that this chain of thought should just keep going along and say, oh, he fired the gun into the house not to kill her, but to scare her. Look, he entered a guilty plea as to a recklessness charge. He's admitting to what he did, but he wasn't trying to do this other thing. That was the accidental part of it. I know that neither of us seems to be buying that theory based on the trajectory, but is it possible that one juror might latch on to it?
It's always I mean, you know, there's also a possibility. There's always a possibility. I don't think it's going to happen in this case, but obviously we never know when we pick a jury, you know, who's on our side and who's not. I happen to think that the evidence is pretty strong, and I think that, you know, while we can accept as jurors or as laymen that are listening to this case that the defendant is a little off his rocker, B, that he definitely was doing things to try to win her back. One would say that at the moment he decided to steal his grandfather's gun, I think the decisions he was making were no longer to scare her and to try to get her back, but instead were entering into a new area, which was potentially to kill her, and then maybe he planned to kill himself. There was discussions about him.
Yeah, look, I mean, we know from one of the friends that he was committed to some sort of involuntary psychiatric treatment. We know that he had mental health issues that raised concerns of people around him who barely knew him at his new college. You've got that. You've got the taking of the grandfather's gun. You've got the discussions we just listened to where he's basically trying to get his friends to help him throw the thing in the river where it would never be found. The Tennessee River is not just a little tiny stream. Right. Goes in the river, probably nobody would ever find it.
But he's blatantly lying to his friends about what transpired, and
yes, that
you
as
know,
well.
and his friends don't believe him because that's why they're agreeing to allow him to be taped. And so, you know, those pieces are also elements of that kind of consciousness of guilt that lead us even closer to him being guilty of the top count.
Well, look, we're going to listen to a little bit more testimony. One of the other friends who was on the stand was McMillan Siegel. He goes by Mac, as my producer Virginia pointed out to me not too long ago. He's testifying about some of these interactions between the defendant and his classmates at college. Now, let's listen to some of this really critical testimony here. McMillan Siegel on the witness stand. He was an upperclassman at the college the defendant was attending. He was basically a mentor appointed to help the defendant adjust from high school to college. As such, he got a pretty strong window into the mind of the defendant. Discussion there, Julie, about struggling to fit into the new environment. Relationship struggles were dragging this defendant down when he went to college. This stuff does play into this defense theory that the defendant was just in some very bizarre scheme to try to win back the affection of the woman who ultimately wound up becoming a victim here.
But I agree with you. I think that there's a lot of evidence that shows that he was trying to win her back, but there comes a point where perhaps he realized he wasn't going to win her back, and so the actions he takes with regards to the gun and the firing of that weapon, and then the explanation afterwards as to blaming it on her, at one point on her herself, that potentially she could have killed herself, brings us in a completely different direction. Remember, this is not some type of, mental disease or defect defense. We all agree that he wasn't probably completely healthy mentally at the time he committed this crime, but nothing about what is described indicates that he wasn't acting, with the wherewithal to know what he was doing was that knowing right from wrong.
Exactly. So look, here's the situation. We've got the friend testifying. You've got all these friends that are basically just saying, hey, look, this defendant is told a number of different versions of the story here. I'm struggling to count the number of versions of the story that it is. He's telling some friends that she did it to herself. Apparently that might have been a rumor that was going around in the neighborhood not long after it happened, but it didn't make any sense to anybody who was close to her. The prosecutor was pretty clear that when it became clear that something was done to this victim, Emma Walker, that everybody close to her immediately suspected Riley Gaul, the defendant.
Right. Of course, everything led directly to him, and he involved all these various witnesses, including his friends and her friends. So he left it inevitable for him to be the person that everyone would be focused on.
I want to get to some more of McMillan Siegel's testimony here. This is where he really starts to dive into the mental health situation with the defendant, the counseling sessions, the treatment, exactly what was going on in his head. Let's listen to this. Testimony there in the Riley Gaul case from an upperclassman who basically was mentoring the defendant, Riley Gaul, in this particular situation. Some back and forth there, Julie, about the phone, who was using the phone. And that's really important because ultimately prosecutors are saying, look, right before the defendant pulled the trigger, he sent dozens upon dozens. I think it was, 50 or 60 messages from the defendant to the victim. But he was using this witness's phone.
Right. So that's a consciousness of guilt because he's, obviously trying to not let her know that it's him or trying to trick her into believing that some serious thing is happening. I guess there's an argument to be made. You could look at it two ways. You could look at it from the prosecution's point of view, that because he's not using his phone and because he's so persistent in reaching her and then eventually fires the gun into the room, that shows the intent and it shows the premeditation. There's the other argument that, he's so, overwhelmed and so crazed with needing her to believe that something's wrong and that there's something crazy going on, that he's going to protect her, that leads into that recklessness that the defense is arguing. Although, again, we go back to where the shot was fired, and I think we lose it again once we get to the shot fired.
I think the state needs to get up there tomorrow at 9 a.m. when the state goes to give the closing argument. Yes. Well, I'm just saying so that when people join us, I know you should be up at 9 a.m. listening to this closing argument, because what the state needs to get up there and say is, folks, this is all about trajectory. I think they need to drive that point home.
Well, I think you're right. I think look, I think what you could say as a juror is, as a prosecutor, is ignore everything else for just 1 minute and just focus on that one shot. Just focus on the one shot. Because if you focus on the shot where it is, that in and of itself is intent to kill. And then you kind of have all the surrounding evidence that establishes that he stole the gun, from his relative, all the various things he did in efforts to try to see her, prior to that, to me, indicate that premeditation exists.
And all the other acts that he made, the using of this particular witness's phone, the attempt to toss the gun in the river,
and the things he did
afterwards. To get away with.
Right, exactly.
Yes.
And the lies he told to get himself out of it. Now, some would say he would have lied whether it was reckless or intentional, so I don't know that simply lying about things proves that it's intentional versus the other, but, in any event, the acts during the commission of the crime, I think, are pretty overwhelming that it was an intent to kill.
We could go on spinning theories about this, but look, if he was truly trying to scare her, which is the defense claim here, why is he doing this at night when she's asleep? Is she supposed to wake up and see the bullet or something and then get scared?
Well, I think they're arguing that some other man is, that he's trying to get everyone to believe that there's a kidnapping going on and that he's potentially the victim of a kidnapping, or that she will be the victim of a kidnapping. And so remember, one of the arguments the defense made is that it used to be that when she was in trouble, she didn't call her mom, she didn't call her friends, she called him. He was the person she relied on. So so he was going to make it so scary that, of course, she was eventually going to come running to him. I don't know quite how we explain away, the shot through the bedroom at 3:30 in the middle of the morning to explain, what she was going to do at that point. I guess the argument is that she would not be killed and call him and say, help me, someone shot. But I think there shows such a lack of logic in his mind as to what he thought was going to transpire if that happened.
Yeah, I mean, we can spin what ifs about this for a while, but I go back to, if he's trying to scare her, it's really hard to scare somebody from outside the house when the person who's attempting to be scared is asleep.
Well, I guess, but that would go better if your argument is that he shot, as you described, into the air or into some other area of the house, that like the kitchen at 3:30 in the morning or something that would have scared her into believing that someone was out to get her, but they weren't going to kill her. So again, if he wanted to scare her, he's surely not going to shoot into her head while she sleeps. That's not going to scare her. It's going to kill her.
Exactly.
So it makes no sense.
State's case in chief. Well, this case is on hold until tomorrow at 9 o'clock when we are expecting closing arguments. The state wrapped today. The defense wrapped without basically presenting a case. So this is all going to hinge on whether or not members of the jury believe this theory that we're discussing, that the defense has insinuated was really behind this. Interesting that we didn't see any attempts to flesh that theory out. No psychologists, no nothing. Interesting tactic. Closing arguments tomorrow at 9 in the morning. We are also monitoring here in the waning hours of the day today the Shawn Grate case out of Ohio. That case went to the jury earlier today. They've been deliberating several hours. If we get close to a verdict, if we hear there's a verdict, we'll certainly bring that to you live. For now, though, let's finish with the McMillan-Siegel testimony that we were reviewing in the Riley Gaul case from Tennessee. Again, this is the friend who loaned the defendant his phone. It was this witness's phone that the defendant used to call the victim some 50, 60 times before he ultimately pulled the trigger. Okay, some previous testimony there in the Riley Gaul case in Tennessee. That case will wrap up with closing arguments tomorrow, first thing in the morning, we understand. Julie Rendelman, Law and Crime trial analyst, is here with me. Julie, we're talking about the defendant who made the decision not to testify. We learned that today. The defense really didn't present any case at all. We know they don't have to, but they didn't. So what the jury's got to go on from the defense is the theory spun by the defense attorney during opening statements and presumably closing arguments, and also the defendant's own words in these recordings, the interrogation recording, which was really hard to hear, and the recording that the friends made of him between when the shot was fired and when he was arrested. And a lot of people are saying that he just comes across way too cold, way too unconcerned. Your thoughts on that?
I have mixed feelings. We always talk about, we talked about this in Tex MacGyver, we've talked about this in numerous cases, that people, the lay people that are watching are troubled by the fact that the defendant in certain cases don't act the way one would expect someone to act when they're grieving. And so in this case in particular, where we, by the way, know that he shot her, we just don't know if he shot her recklessly or intentionally, the fact that he's cold leaves questions for us as to what does that mean. Many people, and this would be a fair argument, is to say that he's completely shocked by what happened, didn't expect her to die, and doesn't know what to do with himself. So he's, acting in a way that's kind of internally going through all the things he's done to her, but also recognizing that he has to kind of do that flight kind of mentality, which is, let me fix what I've done by getting rid of the gun and protecting myself. Now, that actually feeds into the argument that he's just a cold-blooded killer, but, one would think, based on who he was throughout this case, that I don't know if he's, while it's intentional, we have to keep in mind that he's a young, he was a young guy, and so it's troubling on every level to even recognize that this person committed the crime he did, is about to be punished for the crime he did, that he committed, and so who knows kind of what was in his head at the time after this happened.
Yeah, I always get concerned when I hear prosecutors say things like, oh, he's acting way too cold, he's showing no emotion. I don't like it when they do that because people respond to tragedy or people respond differently to different circumstances, but here I don't think the case is going to hinge on that.
Well, yeah, and the difference is he's not only acting coldly, but he's lying, and we know he's lying.
You've got that. You've got the trajectory.
And so he's coldly
acting
acting a certain way while he lies to his friends. And so it's not simply that he's being cold. He just seems incredibly calculating in terms of the various lies he's telling. Now, by the way, the lies he's telling don't make a lot of sense if anyone knows the real evidence in this case, but nonetheless, I agree with you, it's not going to hinge on that, but I think in a way, if he had come out, if we had heard him crying to his friends, expressing remorse that his ex-girlfriend had died at his hands and that it was a mistake and that he didn't mean to do it, then I think we might feel a little differently, and I think that the defense might have a little wiggle room to prove recklessness. Instead, we have someone who comes off, telling these lies and seems a little more manipulative.
Yeah, exactly. So look, this case again wrapping up with closing arguments tomorrow, and we're also continuing, folks, to monitor the situation in the Shawn Grate case out of Ohio. That case, the case where a defendant got caught when someone he abducted and attacked over and over again, according to her own words on the witness stand, had basically broken free from her restraints and ultimately gotten a hold of a phone while the attacker was sleeping after several days of attacks that finally wore him out. And that victim got a hold of a phone, called police. They showed up. They rescued her. They found 2 other bodies secreted away in this abandoned house where the defendant had been living. This defendant faced 23 charges at one point. He entered guilty pleas to more than half of them in the middle of his trial, and now is facing a possible jury verdict on the top charges of murder and kidnapping. Those are the charges that could carry a death penalty. Julie, just to ask you about this one quickly here, he entered a plea on the myriad of lesser charges here.
Right.
The state's still going for the death penalty against this guy if he's convicted. My guess is even if he wanted to plead to those top charges, the state probably wouldn't let him because they know they've got a chance at a death penalty.
Exactly. I think that's why I believe, and I don't know kind of the background politics regarding what happened before this, but I think that that's probably the reason. And quite frankly, I think that if they had promised him no death, I think we would have seen a plea.
We would have potentially seen it before now.
Absolutely.
Too, leading up to trial or something. At this point, no deal is going to be on the table.
No. Although, quite honestly, I mean, there's always concern, especially because we want to know if there's other victims. And sometimes the agreement between the prosecution and the defendant is give us up where the bodies are, tell us where they are, and tell us what you did to them, and we will save your life. That doesn't seem to have happened in this case.
Yeah, and this is a weird one. Look, they've got one surviving victim, okay, and he claims that he entered the guilty pleas to sort of, in his words, quote, prevent rubbing it in her face anymore.
I don't think that's true, but yes.
Yeah, after she already testified about it, that's what he said.
I think he did it to protect himself from certain evidence coming out before the jury.
That's what it would seem.
Right.
Okay, so you've got the so-called rape videos. He was recording himself in the midst of these attacks. Those things didn't come in. Now, in theory, the prosecutor could have introduced them because they would have been relevant to the kidnapping of the non-surviving victim.
Correct.
But Bob Bianchi and I were sitting here earlier saying the prosecutor probably didn't introduce them for fear that it could create an issue for an appeals court to look at later, because you show those videos, yeah, it's going to indicate what went on with the kidnapping, but it's also going to really prejudice those murder convictions.
Exactly. But, and again, I'd love to give him the credit for agreeing to plead in his case, but I think that he really did it. And remember, by the way, it's not just his decision. It's his decision along with his defense attorneys who are strategizing because they know that there's going to be a penalty phase. And so the strategy I think they're using is let's get some of the evidence not before the jury, and let's at least let him acknowledge to the jury that he is guilty of something to make it seem like there's some level of remorse to hopefully have some possibility of him not getting the death at the end of this.
Yeah, I want to also let everyone know there's another case we're following that we expect to begin tomorrow. This is the Jeffrey Willis case in Michigan. Now, if that name sounds familiar, it's because you probably remember he was convicted of killing a young mother named Rebecca Bletch. He's facing a second trial for another victim. Rachel Stockman, our editor-in-chief, has a preview of that case.
The trial of convicted serial killer Jeffrey Willis is scheduled to begin this week. Willis, who was convicted in late 2017 for the 2014 murder of Rebecca Bletch, is accused of the kidnapping and murder of Jessica Haringa. Willis was arrested in connection with the Bletch and Haringa murders after a teenage girl who escaped her abductor identified Willis as her captor. Police later searched his home and van and charged him with the unsolved murders. Prosecutors contend Willis schemed to abduct women so he could rape, torture, and murder them. Willis is currently serving a life sentence for the Bletch murder and is awaiting trial for the abduction of a teenage girl. For Law & Crime, I'm Rachel Stockman.
We expect that case to open up with opening statements tomorrow. We have closing statements in the Gaul case. We'll be back here tomorrow at 9 a.m. For now, this is Aaron Keller. For everybody at Law & Crime, have a good evening.